Good afternoon. Hello and welcome you all to our discussion today. We are going to have a closer look at the recently gazetted online safety bill at our discussion today. The online safety bill was gazetted on the 18th of September and has sparked quite a lot of discussion among the general public. So we are going to have an in-depth discussion and also simplifying the bill for everyone who's here today. I'd like to first say that this webinar will be conducted in English and simultaneous sign language interpretations will be available. Our panelists for today's discussion is Dr. Gehan Gunatilaka, an attorney at law and a commissioner of the Human Rights Commission of Sri Lanka, Ms. Atigal, attorney at law, and Prihesh Ratnayaka, head of social media analysis at Hashtag Generation. Thank you, Gehan, Miza, and Prihesh for joining us. Let's get into the discussion without further ado. My first question is directed towards Gehan. Gehan, if you could give us a very brief snapshot of what this online safety bill is.
Hi, can I be heard? How's the quality of the? I'm very suspicious today of technology because I anyway joined this call a little late. How's the sound quality? Okay, great.
Very
Okay.
good. Yes.
Yeah. So let me tell you a little bit about the main features of this bill, and I think let me begin by saying it's not just about the text of the bill that we need to focus on. We also need to look at the context of the bill and the timing of the bill, right? And it's not a case of only focusing on the text and trying to analyze the text and seeing what the problems of the text might be. The reason I say that is because we also have a wider context where existing laws with fairly clear texts, also provisions that are modeled on international benchmarks. An example that comes to mind is Section 3 of the ICCCPR Act, the International Covenant on Civil and Political Rights Act. You have a situation where even those laws with those model texts have been misinterpreted and misapplied in various contexts. So it's important for us not to get carried away with focusing just on the text of the online bill and also look at the wider context. So you might have a perfectly well drafted online safety bill that meets international standards, that is compatible with human rights standards, all of that. But you might have a practical problem in terms of enforcing that bill, very similar to what you're already encountering with the ICCPR Act. So with that caveat, let me just very briefly tell you some of the features of the bill, and I'll focus on the negative aspects because we can start with that, and there are some positive aspects as well. We can get into that later. But some of the main concerns that I have in terms of understanding the bill, it brings into operation a completely new institution, which is called the online safety. One of the concerns that has been raised with respect to this commission is that it will be appointed by the president and the president alone. So in terms of the hiring and firing of members of this commission, their political independence is not necessarily guaranteed. You might have good appointees, but you might also have appointees that are politically compromised. So that's why you have a system where Constitutional Council recommends appointments to independent commissions. So because of that problem, there's a question mark in terms of the possible politicization of a commission like this, the Online Safety Commission. The other problem with the Online Safety Commission is that despite possible politicization, it exercises very far-reaching powers, including powers to issue notices, power to issue directives, declare or designate locations according to a criteria that we don't see in the bill. So all kinds of powers that are sometimes quasi-judicial in nature. And leaving aside the fact that this commission can be politicized and they'll be exercising such wide-ranging powers, one thing that strikes me about the bill is that these notices and directives and decisions are made without affording the affected party an opportunity to be heard, right? So that's another serious concern that has been raised with respect to the bill, that people will not have the opportunity to be heard and to plead their case before decisions that adversely affect them will be made by the commission. So, for example, if there's a statement that is deemed false or a prohibited statement under the bill on a particular online location or on an online account, the commission can direct that individual, that user, to take down that material immediately. Now, the commission will make that decision on the available evidence without necessarily having to hear that party before making that decision. And that's a violation of very basic rules of natural justice that our constitution and our legal system really relies on. So that's one of the main concerns that have been raised with respect to the commission. I can expand on that during this session, but I want to flag that. Then, in terms of the substance of offences, I'll briefly flag a few features of the bill that might be somewhat worrying. One would be that there are new offences that are broadly phrased, like, for example, a false statement that could be a threat to national security is made an offence under under clause 12 of the bill. Now, what poses a threat to national security, how a false statement can threaten national security, all these things are left open to interpretation. And in that context, we might have situations in which these particular offences can be misapplied to cover a broad range of events and activities. You also have a series of clauses in the bill that replicate similar clauses or similar offences that are already found in the penal code. And the problem there is that the penalties that are being imposed in terms of equivalent offences are much higher under the proposed bill. Now, for example, if you take the causing of or disrupting, let's say, disrupting of a public religious assembly, which is already an offence under the penal code, under the online safety bill, issuing or communicating a false statement that causes a disruption to a public religious assembly that's held in public is also an offence, but with a much higher penalty. And if you compare the two penalties, it's actually 3 times more. So it warrants scrutiny because there's sometimes a lack of rationality in how these penalties are imposed. So for example, if some person goes into a religious assembly and physically disrupts it, they can be held the penal code and face up to a year's imprisonment. But provoking that very disruption through a false statement will be an offence under the online safety bill, but carrying a potentially 3-year sentence. So you can see that there's a disproportionate nature of or there's a lack of proportionality in terms of how penalties are imposed. I'd like to flag one other substantive issue, and maybe we can continue the conversation and the other panelists can chip in as well. It's on the question of impersonation. So again, the clause 19 of the bill replicates the penal code offense, section 399 in the penal code, which makes cheating by personation an offense. And clause 19 follows the same model, where it replicates the elements of that offense with the addition of this idea that it's an online space, right? Now, the reason I'm flagging that is because cheating by personation under ordinary criminal law has a particular meaning. That's where you defraud someone or you deceive someone, causing them some financial loss or some serious harm by pretending to be someone else, and that's why it's cheating by personation. And in the online safety bill, when the offense of cheating by personation is explained, where the elements of the offense is explained in that particular clause, a curious omission is there. That is, the element of cheating is actually dropped from the elements of that offense. So it's called cheating by personation, but when you compare that draft offense with the existing offense, the actual element of cheating is not there. And the repercussions are quite serious, because what it means is any type of impersonation, which could include the kinds of impersonation that you might have in satire, comedy, parody, all these kinds of impersonations that you have online suddenly become criminalized. And you don't have to actually have impersonation with the intent of cheating to be found guilty of that particular offense. So I think uh, the bill stands to really change our online culture, where people have the freedom to, operate anonymously, to engage in satire, to engage in parody, to pass on things in comedy. All of that can be deeply affected if this particular offense is permitted to come into our statute books. So I don't want to dwell on a lot of the substantive points, because I'm sure it will come up with in other questions. But just to flag some of the main problems with the bill, it's the commission and how it's appointed, and the breadth of the powers that it will exercise, and also the way offences are framed, the vagueness and the breadth of those offences, and also how serious those offences would be if they're passed, because of the way in which the elements of the offences have been framed. So I'll pause there for the moment, and I look forward to hearing what the other panelists have to say. Thank you.
Thank you, Gehan. I think you very deftly defined the scope of today's session, and gave inroads so that for the upcoming questions as well. My question is next. The next question is to Ermiza. So Gehan discussed about the restrictions that this bill would pose, and national security, religious harmony, so on and so forth. So I would like you to briefly explain to us how and if the provisions of this bill impact the freedom of expression in Sri Lanka, and whether it is impacted in an adverse manner. And also to discuss in tandem, if possible, to see if there are any additional restrictions or restrictions imposed other than the restrictions that are prescribed in Article 15.
But hello.
Yes, now you're audible.
That's good. But it's nice to be with you all. Talk, and it's really timely that we're talking about the online safety bill. The bill having been tabled in Parliament today. So on the question that was posed to me, and I think I agree fully with what Gehan also said in terms of the fact that we need to really take the entire bill and its specific provisions in the context of Sri Lanka and how law has really been both misapplied, so that means it's been wrongly applied to the situation, and also it has been selectively applied to particular individuals who have, on most occasions, we see either critiqued the individuals or the government of the day have been activists raising concerns, human rights activists, have been artists who have been raising social concerns that may have been believed by those employing the law to bring certain disrepute or ill will and hostility and feelings of distress, right? So when we have a situation or a context in which those who wield the law, those who are the police, who are the ones who will exercise this law, having a history, having a clear practice of using the law not necessarily always in the correct way and using the law selectively, then those are very serious concerns that need to be addressed in any incoming new laws. Having said that, I just want to add, before discussing the online safety bills specifically, that lawmaking in Sri Lanka needs to be something that we talk about, because there have been, particularly this year, we've seen many pieces of legislation, proposed legislation, that the public have to consume in a short period of time and respond to. And I think really we need, as citizens and also as lawyers, to promote this idea that we do have more time in being able to understand why a law is being proposed. And there has to be a stronger sense of responsibility by those advocating for these laws and proposing these laws, to say this is the context we are trying to address. This is the problem or the mischief we are trying to arrest. This is what is happening in Sri Lanka, and this is why we need this law. These are the number of wrongful acts that have happened over the last so many periods, so many years, and this is why we think this law is necessary. And also, these are the laws we have in the country, and these are the gaps, and therefore we are bringing in this reform to fill that gap, to correct that gap. Because it seems very often in these laws, particularly also in the online safety bill, that there is a replication of offences, and I think Gehan also adverted to this fact. When there is this replication of offences, you can also use the penal code, and you can then, this law also says it's an offence, but has a higher penalty than those who wield the law, the police in particular, will then get to decide which law is appropriate, who gets prosecuted under the offense that attracts the higher penalty. And then we see, as in the past, possibly targeting of minorities, targeting of activists, targeting of particular groups or even political opponents, right? So it's in this context again, I think it cannot be said enough, particularly when we discuss new laws in Sri Lanka, that the context, particularly criminal laws, the context is really, really important. So having said that, the entire scheme of the online safety bill is about restricting freedom of expression. Freedom of expression is the guarantee under the Constitution. Under Article 14 of our Constitution, we are guaranteed, and as you say, Article 15 has some basic guidelines and sets out the criteria on which that right can be curtailed or restricted by law. And this is then going to be a law that comes in to curtail that broad right. Both governments, individuals, and companies all have to start from the basic premise that everyone has the freedom of expression. That's where we start from. The starting point is full freedom of expression. Thereafter, we very carefully, deliberately think of what is the illegal act that we want to curtail, what is the harm that we want to address, and create laws just enough to carve that harm out and to negate that illegal activity. However, when we read the online safety bill, there is a host of offenses that have been created. And if you look at clauses 12 to past 20, there is a series of offenses that refer to words that have been broadly, that have not been defined in the act itself. So, for example, one of the offenses, and it uses this word very often, false statement. The definition of false statement in the bill is that the statement is, the maker of the statement believes it to be incorrect or untrue, and the maker of the statement intends to deceive or mislead another. So it's a very subjective opinion to the maker of the statement. So when it is worded that way, the idea that someone else will decide then that you are committing an offense, there's a lot of leeway, there's a lot of room. Thereafter, based on this fairly broad idea of a false statement, it goes on to create offenses that says if this false statement poses a threat to national security, public health, or public order, which if we look at Sri Lanka's laws, we already have laws that deal with these areas of national security, public health, and public order. But this repeats it here. It also says false statements that promote feelings of ill will, hostility between different classes of people is also an offense. And in a country where we are really dealing with daily almost, well, maybe that might be too much to say, but regular incidents of disharmony and the opportunity to create and thereby mobilize this law becomes, the potential is very high when words like this are used in a law. So promoting feelings of ill will and hostility between different classes of people has been made an offense. Contempt of court, although contempt of court is something that we already have in our law, it is also mentioned in this online safety bill. Causing disturbance to an assembly engaged in religious worship and ceremonies, and we can think of instances easily in this country where this can be applied, misapplied, situations created and groups targeted. Wounding of religious feelings, outraging the religious feelings of any class of persons, insults or attempts to insult a religion or religious belief. And we have seen how this has been, this kind of offense has been selectively mobilized against some individuals and not others. So we are very concerned about this type of language and how it will be used. And then, as Gehan mentioned, by online accounts pretending to be some other person, substituting yourself for another, representing yourself to be another. So even in jest, for the sake of entertainment, for the sake of political satire, that pretending to be another person becomes an offense. And there is a whole host that gets created, and I'm particularly concerned because there is an offense that has been created that where there is a code of conduct which the commission, Online Safety Commission, can create a code of conduct. But when that code of conduct is also violated, there is certain liabilities. If that violation of the code of conduct causes loss to another person, this bill says that there's a liability to pay compensation as well. So we don't even know what's going to be in that code of conduct. That is to be determined in the future by the commission, right? So the potential for very many acts, particularly in this context of Sri Lanka, to attract criminality, to be also easily mobilized against individuals, is of serious concern and restricts by the provisions themselves the freedom of expression of individuals, because I would say that fairly ordinary conduct, legitimate conduct, dissent and critique against government activity has great potential to become targeted under this law, and particularly when you do it online. So it is then really important to understand that so much criminality, so many offences being created is a severe restriction of the freedom of expression in Sri Lanka. And just to go one step more, I would say that it creates this chilling effect, because those who use the internet, those who create content for online sites, those who facilitate others to access these online web pages, these forums, these chat forums, all suddenly become worried about the fact as to whether or not they are engaged in an activity that may attract these offenses, or may be perceived by the person who is using this law that they are possibly treated then as a suspect, or someone who against whom the law can be or can be arrested, and order can be made, and notice can be given. And that creates this chilling effect, which we may not be able to measure, but will certainly lead to self-censorship of individuals engaging in vibrant exchange of information and ideas that are very important for democratic life in Sri Lanka. I will stop there.
Thank you, Amisa. With that, I would like to direct my next question to Prihesh. This proposed bill, if it becomes law, will have a severe effect, a restricting effect on freedom of expression in Sri Lanka, particularly on online spaces, social media spaces, and other civic spaces which predominantly sometimes use online platforms for their activities. What do you think is the impact of this bill on those spaces?
Yeah. Hi. Yes. I think most of this was covered by the two speakers, but I'll add my 2 cents to it. So currently, as you all know, like social media is used by almost everyone now, and many has to it throughout the country, and it is like everyone's bread and butter now. So to understand this, why they are bringing the bill now, we can also look back at the past 2-3 years and understand why the bodies would want a law in place, because there were many like the last year with the crisis and protests, social media was one tool that people had to bring out their voices. So at the look of the bill, it is to be seen that it is to curtail freedom of expression, very rightly said by Amisa and Kehan. And also I think it is also disables the right for information of the people as well. So I will start by like talking about the Online Safety Commission, which this bill tries to bring out. So this Online Safety Commission is appointed by the executive, and it is not even independent on the paper. So, and it is not even like ratified by the parliament, but the president has the power to appoint members. So how can we think like it will be independent governing body putting out this if the law comes into place, that everyone would be treated equally? Because as Amish said earlier, like selective application as any other law could be expected, because we have like very good legislation in place, but it is not being applied to every case equally. And on civic spaces mainly, this the definition of false statements and prohibited statements is very vague, and people who use this space to express their opinions, express their views, may feel that they will be targeted if they are against the current regime, or they have different views, especially in the minority communities. And also because this bill has very vague terms of like ill will and hostility between different classes of people, and it is not defined any further. And this could potentially impact freedom of expression, as these individuals will be very cautious about sharing information and expressing views online due to fear of legal repercussions. So the other thing is the Online Safety Commission has the will, like they want all the websites to provide social media platforms to register with them, and they would issue codes of practice for these internet intermediaries and service providers. This might impact in two different ways. So these service providers may not want to register, and they would not give out this service for the Sri Lankan citizens, which affects like disables access to information for the Sri Lankan public. And also due to fines and stricter regulations, the online platforms may move to over moderation, which could impact like for them this is just another law they have to be clear of. So they might, instead of having more resources to monitor Sri Lanka related content, given the market size it's very small, they would move to over moderation, which would result in curtailing freedom of expression of the people. So those are the main ways I think that this could impact the civic space.
Yes, I have a small follow-up question to you, Prihesh, on that. So if I say me as a person, if I share or create maybe parodies, I think Gehan also and both Ernst and Gehan touched upon this briefly on the type of content that will be impacted. Can I post memes? Can I post parodies of certain things? Satire. So, what kind of content do you think will be impacted or heavily impacted, or people will fear to post as a result if this act is enacted as a law?
Yes. So in Sri Lanka, parodies and satire has been like a main way online to show public dissent, and it has worked very well throughout the past years because the public engages with satirical content more. I guess so. These parodies and satire is mostly intended as like humor or critique and not to deceive people. But from this law, it could be misinterpreted or misrepresented as to how that it is. It might not be considered, but it might be satire, but as a false statement. And who decides what's false and not is also not mentioned in the law. And what powers does this online commission has to decide whether this species this information are like false is not clear. So whatever the commission decides to be false might be taken down, and those individuals may be imprisoned or given fines. So this also again is limiting the civic space, and there are lots of online activists who use like for the lack of a better term, like fake accounts or pseudo accounts, because they are fearful of their real identity being out there. So they use these accounts to put out their dissenting views, or for like whistleblower articles and so on. Like it's mostly online activism. So it's a common practice in the world to use such accounts so that they can protect their identity. So from this law, it will curtail that their freedom of expressing themselves, and these if these are found dissenting or like challenging the whoever the government is, these people could come under harm. And since the commission has the power to like declare online locations and ask the service providers to disable access of the user or that platform, the other public also would not have access to such information. Yeah.
Thank you, Prihesh. My next question is directed to Gehan, and it's going to be a little bit more substantive. And Gehan, what do you think about the definitions on prohibited statements and false statements? Can we discuss it in a little bit more detail?
Sure. I'm guessing I can be heard, right? Okay. Let's start with false statement, and what's important is we have to look at definitions and how the definitions apply in the various substantive sections of the bill, right? The definition of false statement, it's all defined in the interpretation clause at the bottom of the bill. I think clause 56. And false statement means a statement that is known or believed by its maker to be incorrect or untrue. So that means the first element is that the person who's making the statement has to either know or believe that it is untrue, right? That's one element. And then is also made with a specific intent to deceive or mislead. So then there has to be knowledge and intent for something to become a false statement. Now bear that definition in mind, right? Definition alone, I don't have a big problem with, because it seems to have a fairly high threshold. And when you have a high threshold when it comes to criminal offenses, that means the person prosecuting has to prove that the individual had knowledge that it was untrue, and also the intent to mislead or deceive. And most criminal offenses that involve a speech element or particular action will have these types of high thresholds. So then the prosecutor's burden is quite high. You have to prove that the person had knowledge, and to prove that the person had that particular intent in order to secure prosecution. So I don't have a big problem with that definition. My problem is how the definition then gets applied in the various other sections of the bill. Now, if you go, so that's the interpretation clause. Now, if you jump to clause 11 of the bill, that sets out all the powers of the proposed Online Safety Commission. And clause 11, subclause C, gives the power to the Commission to issue directives to persons who communicate prohibited statements under this act, to stop the communication of such statements. Now, on many occasions, the prohibited statement is based on the fact that it's a false statement, right? And that's why all of these things are connected. And I'll come to the definition of prohibited statements in a moment. But remember that many of the offenses that make some statement a prohibited statement has as an element a false statement, which means that definition that I also spoke about in terms of false statements is relevant to this particular clause. Now, the Commission has the ability to issue directives to various people to prohibit the communication of such statements, right? And often these are false statements that it will be focusing on. Then you go to clause 25, which says that a person who fails to comply with a directive issued under paragraph C of section 11, the paragraph that I just mentioned, within 24 hours, right, you can face conviction and face imprisonment up to a period not exceeding 5 years. So false statement, Commission issuing a directive, then failure to comply within 24 hours, and you can end up with a 5-year sentence, a prison sentence. So it's very serious how this definition plays out. Now, here's the real problem. As I mentioned earlier, the directives of the Commission will be issued without necessarily having a hearing. The bill doesn't specify that a person against whom a directive is issued has an opportunity to be heard. Perhaps that opportunity can be provided through, say, regulations or rules, but that's not there in the bill, so there's no guarantee. So now the question might be legitimately asked: how is it that the commission can come to a reasoned conclusion that someone is making a false statement and therefore a prohibited statement without actually engaging that person? Because if you go back to the definition, the definition only talks about knowledge and intent. How do you establish knowledge and intent as two separate elements without actually engaging that person? Because it's that person's subjective knowledge, subjective intent that makes a statement a false statement in terms of the bill. So it's not just a question of looking at a statement and thinking, oh, this is not true as a matter of fact, and therefore we can issue a directive. No, no, no. For it to be a false statement under the bill, that knowledge and intent has to be also present. So then there's an internal problem in the bill, an internal structural problem, where the commission will be issuing directives on the one hand, using or relying on a definition that involves uh, knowledge and intent, but on the other hand, not really being required to engage the individual concerned, the individual who is making the false statement, right? And I think that internal contradiction, the structural problem, reveals that not enough thinking has gone into the drafting of this bill. And if more thinking had gone in, that problem would have been identified, and then it would have been required that the commission relies on an order of a court and evidence in a given case and comes to a reasoned conclusion that a false statement has been made before this directive is issued. But of course, the whole purpose here is to issue directives as soon as possible and not wait for a trial to be concluded, right? So this establishment of facts and coming to a reasoned conclusion that someone has made a false statement is really much better suited for a criminal proceeding where there are elements of offense. Prosecution has to establish those elements, and the judge comes to a conclusion. For a commission to be deciding whether something is false or prohibited, already there is a structural problem, because the commission can't do it, can't come to that reasoned conclusion without actually having a hearing. So I think this is revealing in terms of how the bill has been drafted, and the rushed nature of the whole thing, because things like that may have been spotted had, as Amisa mentioned earlier, had there been a more consultative process. So that's false statement. Very briefly, prohibited statements, the definition that is in the bill is a definition that goes back to the substantive clauses in the bill. So a prohibited statement is basically any statement that is actually prohibited by clauses 12 up to 23, if I'm not mistaken. So then you have to go to those specific clauses in the bill, the substantive clauses, and see what is prohibited, right? And then the cumulative effect of all of that will be the definition of prohibited statement. So each of those clauses will prohibit different things. So a false statement to disrupt a religious assembly, a false statement that causes a riot, a false statement that causes mutiny, then impersonation, a statement that involves some kind of impersonation. All of that will fall within the definition of a prohibited statement. Now, if I were to make one quick observation there, I would point people to clause 22 of the bill. And I think that's where things get very tricky, because clause 22 of the bill prohibits a certain type of activity that many of us are accustomed to. That is where images of some kind are communicated or posted without the consent of the individual concerned. And now you have, on a spectrum, you have very serious violations where intimate images are posted without consent, or images that are humiliating in some nature, right? So that's at one end of the spectrum, and there is a strong case for such types of activity to actually be prohibited by law. But on the other end of the spectrum, you have images of a person that might be posted online without consent, which might be a violation of privacy, but not necessarily coming to a threshold of requiring a criminal law response, and maybe civil proceedings of injury and damages is the better domain for that. So the illustration in clause 22 is quite revealing. Or the second illustration B, is where two individuals, X and Y, were formerly in a relationship which has since ended, and then X posts a photograph of Y in the possession of X, which Y could reasonably have expected to remain private. Now that is a very broad definition, and that involves even non-intimate photographs that you might have of someone in one's possession that you then post, and that might be certainly cause for injury and cause for damages in civil proceeding. The question is whether it ought to be a prohibited statement that constitutes a criminal offense, because X becomes guilty of an offense under this section in relation to such a post. And the threshold there is not that harassment or intimidation or humiliation or complete violation of someone's dignity is caused by the posting. It also involves distress. And in the context of a relationship ending, you might be distressed as a result of your partner posting even a picture that is not intimate in nature, and that distress can be caused by a variety of contexts. But that would be included within the definition of this clause, and therefore the definition of prohibited statements. So prohibited statements have a wide-ranging list of statements that fall within its definition, ranging from serious statements of inciting riots all the way to distressing posts of ex-partner, which also falls within this definition. So then the question arises as to how a commission can establish all of that, including the distressing nature of something, the subjective distressing nature of a particular post, and then issue a notice without a hearing. So I'll pause there, and hopefully I answered your question.
Thank you, Gehan. That was very clear. I would like to direct the next question to Mirza. We spoke very briefly about the punitive provisions and the lack of proportionality when it comes to the penalties imposed. What is your take on that, and why is it bad that there's a disproportionality, and how could it really translate in a practical sense if this bill were to become law?
Okay. So, as I think also Gehan mentioned in the first opening remarks, that there is that disproportionality in the way penalties have been assigned, taken when we contrast it against offenses in the penal code, for example. So reading through the bill, it's fairly clear that there are very high penalties that have been imposed for the various offenses. And when it comes to the internet service providers or the online locations themselves, and the penalties get higher and higher still. I think this really comes to my earlier point as well. It's difficult for us to understand without the information being provided by those who are proposing the law, really, as to what was taken into consideration in coming up and how they came up with these penalties. It really seems, by just a reading of the bill, that there are arbitrary high amounts have been jail terms of imprisonment, and fines. There are high value have been assigned to these offenses and non-compliance with certain orders. So I think it's that fact, when we know that compared to the other laws that are present in Sri Lanka, that are also very effective when used against wrongs, illegal activity, harms that are caused, when comparatively higher penalties are available in the law, merely to harass, merely to scare that is the law then that may be used by the person wielding the power. So in this act, the people wielding the power are the commission itself and the police who can initiate, right? And even under a bringing matters, making complaints, even individuals can initiate matters before court. So when there are higher penalties, there is a greater fear of those who may, looking at the wide array of offences that have been described in this bill, may think I may be caught up under this particular offence or any one of these offences, and therefore starts to curtail their online activity, curtail their interactions, curtail their expression of ideas and opinions. And I think it has a very, the potential for it to have this chilling effect really over how we engage over these public spaces is very great. Additionally, looking also at how these laws have been used in the past, similar laws, the harassment that is caused to an individual that may be targeted by these types of laws, and then this particular law in particular, if it were to be enacted, by being subject to the law, then brought before, let's say, the provisions which relate to a court, and having to make those submissions to say that this statement was in fact not false and therefore should not be a prohibited statement, and the time it takes for a case to even conclude, it has already attracted a host of litigation costs, emotional distress, difficulties, and we know even with acts like the PTA that is where many of the individuals were unfairly and unjustly harassed. And this is one of the reasons why laws of this nature, there has been really such a growing public opinion about not having similar laws, or how these provisions have really affected the lives of individuals either engaged in fairly ordinary, going about their profession, going about whether that profession is the legal profession or whether that profession is the arts. And that activity has attracted this kind of harassment where people are engaged or embroiled in litigation for years sometimes, losing a lot of resources, causing a lot of distress to themselves. So I think what the potential is not just the penalties, which are clearly high and therefore in themselves cause fear, but also the potential for the misuse, misapplication, and the selective use, particularly against minorities, political opponents, and the harassment that can cause is really concerning at a time when we do need in Sri Lanka a very vibrant space for all of these ideas. When the country is going through difficult periods, even if it was not, democracy requires that individuals are able to express themselves, share ideas, and critique government in particular. So this, and I think in that sense, the timing of this piece of legislation really is something that we need to subject to critique, and why it's been rushed through. I know we have a history in Sri Lanka of rushing through legislation, and that is bad practice. We really need to be moving away from that. With a law like this, where there is severe curtailment of freedom of expression, there's dangerous potential for repression under this law. There has to be wider and greater space for public debate, easily, I would say, taking in other countries years to engage in the proper debates and put up the material that is necessary. The experts weigh in, individuals weigh in and say, this is what will work, this is what won't work, and we make laws together. Not in this way where we are ambushed by a law which I cannot even explain the logic behind how these fines and penalties came about.
Thank you, Amisa. I would now I want to look at zoom a little bit back and see in a stakeholder perspective of things. And this question is directed to Gihan. So it's not just the people in Sri Lanka, the government of Sri Lanka involved or have a stake in online spaces. Big tech companies and other service providers also have a say and have a stake in this. From that, from the perspective of tech companies and service providers, and also perhaps the international civil society, how do you think they would respond, and have there been any responses so far?
Yeah, there has been a response yesterday by the Asia Internet Coalition, which includes a number of large tech companies, including Google and Meta, and I think eBay. There's a whole list, and their statement is pretty clear that they are very concerned about this bill. And it appears that there was not much consultation even with those tech companies when the bill was drafted. I'm not aware of whether such consultations took place or not. The statement seems to be very clear that they are concerned, and they're calling for more of a consultative process. Now, leaving aside the very serious rights-based concerns that we have raised so far with respect to the bill, the more practical economic concern that could be raised is that Sri Lanka is ultimately a very small market. If there are laws that are brought in that affect large technology companies and their operations in Sri Lanka, and those companies weigh the pros and cons of complying with such laws versus withdrawing from the market altogether or limiting their services in the market, they may pick the latter. We don't know how these tech companies will make a decision. Remember, we're a small, insignificant market. It may not be a major economic loss for those tech companies to limit their services, by looking at the law and saying this is not worth our while. The question is whether Sri Lanka can afford that, right? And I'll leave it to the economists to make that call and to look at the repercussions, particularly to small and medium-sized entrepreneurs who operate online, some of the bigger companies that rely on the online space to be free to use without fear and without restriction. All of the repercussions that might flow from a bill that puts a lot of emphasis and vests a lot of power in this fairly unaccountable online safety commission. What those repercussions are may be quite significant, and I think economists and those who are experts in that field will need to look at that and give an analysis of those repercussions. My guess is that the problem with this bill is not, of course, it's a rights-based problem, but it spills over to other spaces as well, and I think the economy could face some repercussions if companies decide to withdraw from our market, decide to limit their services in this market, and that affects the stimulation of our digital economy as a result. So yeah, I think that's a very valid question to ask. In terms of the international organizations, I think the International Commission of Jurists have already come out with a statement looking at the bill. I'm sure others will also come out and have their views on the bill. There's an interesting analysis done by LearnAsia comparing this bill with the Singapore Protection Against Online Falsehoods Act, and showing how, even though a lot of the bill has borrowed provisions from that act, there are also significant differences, and also pointing out the fact that that act was brought in with after a consultation with relevant stakeholders. I think you will have people coming forward with international expertise also making their comments known and their observations known on the bill. But now that it's placed on the order paper of Parliament and it's been presented to Parliament, the next 14 days will be available for people who wish to challenge it before Supreme Court to take that step. And I imagine that would be taken because of the sheer volume of individuals and organizations that have come forward criticizing the bill.
Thank you, Gehan. So I think it's also important now that you mentioned the protection, the Singaporean Act Protection from Online Falsehood and Manipulations Act, the POFMA also. I think it's also pertinent to look at similar laws, whether there are similar laws being enacted in other countries in the world. Perhaps Prihesh can give us a small overview of the existing examples of similar laws in the world.
Yeah. Yeah. So, Kian already mentioned the PAFMA by Singapore. So, it's mostly similar to what we have here for now, but there are also some differences there. It is similar that the government has the power to address online falsehood and misinformation, and the act allows the government of Singapore to issue orders to correct or remove false statements, disable inauthentic accounts, impose penalties on platforms and individuals for non-compliance. Similarly, another controversial law is the Network Enforcement Act in Germany, called NetzDG. So it was enacted in 2017, and it requires social media platforms with more than 2 million registered users in Germany to remove or block access to illegal content within a specified time frame. So here also in this law they mentioned 24-hour period for clearly illegal content and 7-day time period for illegal content as mentioned there. So I think we also have in our law that removal period is 24 hours. So I think this may have been taken from this law. And the other thing is platforms are required to publish transparency reports biannually and show that they have established mechanisms for user complaints and content moderation. So these transparency reports should have how much resources each platform has allocated for these cases and the reasons for taken down and so on. And in Australia, there's similar called Online Safety Act in 2021. It has a safety commissioner, and it also provides various regulatory framework to address online safety issues, including non-consensual sharing of intimate images, cyberbullying, and harmful online content. This act also includes provisions for content moderation, user complaints, and removal of harmful content. Currently, I think in United Kingdom, online safety bill is currently there, and I think there's another bill, I cannot remember the name. So far, the online safety bill aims to establish a regulatory framework to address harmful content and activities on online platforms. So this bill proposes to establish a duty of care for online platforms to protect users from harmful content and activities, including illegal content and content harmful to children. The other bill, I think it's still under discussion in the parliament, is somewhat a bit more controversial than this. It talks about users being registered on these platforms, like using their actual identification. So that the users on a particular platform will not converse with whoever's not will have the option to know whether that account is like actual person or not. So this has garnered a few criticisms, but it's yet to be seen if this will go through in the UK. In India also there's a similar law, the information technology. It's more like a ethics code, intermediary guidelines and digital media ethics code. It was enacted in 2021, mainly for intermediaries, including social media platforms and digital media. The rules include provisions related to content moderation, user verification, user complaints, and removal of illegal content. So these rules have been subject to discussion and legal challenges related to, same in Sri Lanka, freedom of expression and user privacy. The one that's mostly been spoken about in the industry is the Digital Services Act from the EU. So this was proposed in 2020. I think it is going into force this year. So this is a regulated framework for digital services, including online platforms. So the DSA includes provisions related to user complaints, content moderation, transparency reporting, and the liability of online platforms for illegal content. This law aims to balance the online safety and also while protecting the freedom of expression. So there are a few different problems with these laws, mostly with like Germany law and Singapore, it's over censorship because the hefty fines on these platforms may encourage the platforms to go for over censorship, like or over moderation, like I mentioned earlier. That would limit like freedom of expression of the public. And one other problem commonly across all these laws are like broad definitions, and whoever the most raise concerns about the definitions of these harmful content, like illegal content. These terms are very broad and thus have an impact on freedom of expression. So I guess that's an overview of the bills.
Yes. Thank you, Priyesh. There's one other question I want to direct to Urmiza, but I think the Gehan and Priyesh can also pitch in if it's more of a suggestion-oriented one. So that we see this act is having a very protectionist, reactive approach to like protecting certain certain things towards perhaps like arbitrarily and restricting the freedom of expression severely in doing so. And we also talked about how the Online Safety Commission has a vast amount of power in regulating this. So in your opinion, could there be an alternative approach? So this is an online safety bill, perhaps a preventive approach looking at digital safety. Do you have any suggestions as to how it could change, if at all, to address the issues that the Act looks at?
Okay. No, thank you for the question. I think that's a great note to start closing down on. And I think the entire sort of scheme of this particular proposed law is about criminalizing conduct and creating fear, which is what will result. And I'm not too sure as to how much of it is reactive, but certainly very deliberate in how it has been designed and what it seeks to do. In what would be a better way of going about it is really about looking at both how systems are not working in countries like ours, right? So we also look at agencies with power, how they use that power, what is the accountability for those mechanisms. So, for example, in this bill, we have a commission that is control. The appointments to the commission are by the president. The those individuals once appointed can be removed by the president for reasons assigned, which could be anything, right? So it is totally within then the control really of the office of the president that these individuals then, given that dynamic, would function. There is really a need for greater conversation, encouragement of conversation, transparency, and accountability over and around this area of online safety and preventing online harm amongst all actors. And I think governments really should not think that the only recourse or response to online safety, and the problem with this laws and particular types of times of government and and governments of the time, is that one really feels that it's not necessarily also responding to problems, but also using the moment in a way that expands powers that can be then used for various other interests and other purposes. And that is really the problem that we are all concerned about right now. But if we are really concerned about online safety and the harms that are caused online to individuals, then it is about understanding what that environment is, creating greater transparency about how you go about understanding what a false statement is, what the impacts are, talking more about those impacts, advocating for good practices, best practices, working in partnership with citizens and companies to create mechanisms that can be deployed to have that greater transparency and have that accountability. Creating criminal offenses is one limited arm of the response. It cannot be the entire response. If it becomes the entire response, it becomes a very repressive, often overly broad, and the question of necessity and proportionality really come in. And I think when looking at this particular bill, we see that the offences that have long been advocated for, that we needed some changes in the law, questions on online child abuse related issues, or online sort of cyber violence, and issues around sort of relationships and sharing of images and things like that have been real concerns. But there could have been very specific amendments to existing laws or specific laws brought in to address those. On the strength of those real but limited concerns in this bill, there is too much of a wider control, broader set of offenses, and real fears that then it attracts for sinister ulterior motives to then sort of control this piece of legislation. So what I think what you really need is to promote that transparency also within government to its citizens about actions it takes. Create more consultation around laws like this. Take the time that we need to develop an understanding of the problem and the response we need to provide. In fact, even in this bill, it says that the Commission shall can create sort of more regulations. It's been given the power to do so. And even those rules have a 2-week public consultation period. I think this is a really bad practice to go into having such limited spaces for public consultation over matters that govern their rights and freedoms and the ways in which people just naturally interact. And those rules and restrictions, when they come in, are long term, particularly also in a country like Sri Lanka, where we don't have, unlike many other countries, most other countries in the world, we do not have the right given in our constitution to question laws, to complain to court and say that these laws, these provisions in a law are infringing our fundamental rights. So we lose that opportunity. We only have this limited capacity to challenge a bill before it becomes a law and say we think potentially there could be a violation because there are provisions that are not consistent with the Constitution. But after the law comes in, we are all silenced. And in that scheme, with that design, it becomes really more important that there is a lot of public consultation before coming into enactment of laws like this. So I really hope the other speakers have other ideas as well to add to how we can move forward as opposed to bringing this into law.
Gehan, Rahesh, would you like to add on to that?
Yeah, I agree with Nisa completely. I think criminal law is not the way to deal with this issue as a sort of panacea or a single solution. There are some types of online content that requires a criminal law approach, and that at the top of that list is incitement to violence. Our laws are sufficient in terms of covering that. The question is whether it has been actually applied to deal with incitement. And if you look at the track record of the ICCPR Act, it's clear that although it has been used to arrest individuals who have caused offense, particularly religious offense, it hasn't been successfully used to prosecute and convict people who are involved in the incitement of violence. So that there is a problem in terms of enforcement that is already in existence. So the criminal law approach really should be confined to dealing with that kind of online harm. Whereas other kinds of online harm, particularly where you're talking about offending people or defaming people, there's a logic in confining those types of issues to the civil domain or a regulatory domain, where if similar to how licensing regimes are introduced, you have a licensing process where if people who run particular platforms commit violations, where a lot of harmful content is found on those platforms, some kind of regulatory mechanism is to regulate that. But all of that really needs to be discussed in a context. Law enforcement authorities and institutions really have the capacity and the will and the intention, the motivation to apply a regime in good faith. And that's why I think any kind of solution needs to be accompanied with institutional reform. And certainly criminal law approaches should not precede institutional reform, because we are already seeing the problem of existing criminal laws being applied in a way that's not even-handed or consistent. So I think institutional reform has to come first, and then we can trust these institutions to apply either criminal law in certain cases or regulatory regimes in other cases. So that still leaves the question open. How do we deal with the prevailing problems that we see in the online space? And some countries have taken a slightly different approach, where accountability is imposed on even powerful actors in the digital arena through codes of practice, industrial codes of practice. And we've seen countries like Australia, New Zealand, in regions like the EU, where industry codes of practice have been used to not only get big tech companies to agree to a certain set of minimum standards that they will comply with, but also to hold them accountable through as an industry. So here it's not just a particular company that signs on, but the entire industry signs on. And there's an attraction to that kind of approach, because if one of the members of that whatever coalition that signs on fails to adhere to certain standards that they've promised to comply with, there is a peer pressure that is going to be imposed, and there's a naming and shaming and a reputational cost that a lot of these companies take very seriously. So I think it is worth exploring that model in the Sri Lankan context as well. And I know Hashtag Generation and several other organizations have been involved in such an initiative where the industry code of practice has been drafted. And it's a pity that that kind of approach hasn't been even given a shot, even tested before we go into legislation. And it's a pity that even some of the big tech companies that initially wanted to sign on to that process haven't signed on yet. And I certainly know that some of the big tech companies have pledged to support it, have pledged to sign on, whereas others have not. So I think if we're looking at solutions, those are the types of solutions worth exploring. And they may fail and they may not be successful, but without exploring it, rushing into a criminal law approach, I think is probably a mistake.
Priyesh?
Okay, so I don't have much to add after Misa and Kehan. So what I want to tell is the multi-stakeholder approach is really necessary. And with big tech companies, we are not saying that they are like good. They have to get their game up. But this law has been done without any consultation with them. So just like in, I guess in Pakistan, when they were required to register this, the AIC stood up and said they will move out of the country. So it could be the same with us. So the best move forward is like we have to hold these big tech companies accountable. That's for sure. But how we are going to do is the problem. Like Jan mentioned earlier, the AIC had put out a statement because this law is very draconian, and they'll be open if there are changes. And I guess the code of practice is one way to move forward, and it is actually a pity that it did not go through. I hope, if not sure whether we'll have that option in the future, but I hope we would go through. And the other point I want to touch upon is what Gehan mentioned about institutional reform, especially in the law enforcement. So to give you an example, there are currently laws in place to deal with the issues mentioned specifically in this bill. For example, cheating by impersonation. So when there's a fake account impersonating you, there are laws that can be applied in Sri Lanka as well. There's been cases that's been done, and the magistrate has issued orders to these companies, which these companies are bound to follow, and they have followed it when it is through a magistrate order. So what happens now is the law enforcement has very less capacity, and they do not treat these things as important. So I don't think bringing out a new law will change that. For example, if there's a fake account in a name operating and putting out obscene publications or like non-consensual images or videos of yourself, when you go to the police to complain, there's a specific division also to complain these laws. They ask to find out who the person who's doing this and come back. So I don't like, how can a person find out that? That's why they go to the police. But the police says, if you know the person, come back. If not, they can't do anything about it. But that's not the case. There are laws and there are ways that they can do it, but it's not being implemented. So the purpose of this law, bringing this law without improving the capacity of this law enforcement and other authorities in Sri Lanka is not going to work. So this law, what we can see is to curtail the freedom of expression and remove the right of access of information of the public.
Thank you, Priyesh. I think with that we can wrap up the main discussion. We are like 5 minutes over time, but we do have a few questions that came from the audience. Perhaps you can briefly address them. There's one question on whether political cartoons can also be targeted, and like my extension to that question would be, most often the political cartoons that go on e-paper also we have on the printed media. So would those also be then by extension criminalized and censored? What is your response to that, perhaps, Misa or Gehan?
Dan, do you want to take that?
Yeah, sure. Sure. I mean, we've probably answered that question. Any kind of communication, whether visible in sort of verbal form or through image, will be captured within the ambit of the bill once it's posted on on an online location. And online location is also defined in the bill to be very, very broadly phrased. So that could include any kind of content on a computer that is accessible to other people. So yes, I think political cartoons, depending on what is depicted, can very well be considered falling within the definitions and within the ambit of the bill, and you will have to look at all forms of expression, whether verbal or pictorial form, as possibly coming within the ambit of the bill.
Yes, thank you, Gan. I think an interesting insight, like a bit of trivia, would be that there was a cartoon by Avantha Article today with just a complete black, it was just black screen. So I think it's also a form of, it's a wake up call for us in everyone who is watching and, think these things happen. There's one more question. We have actually covered it, but specifically the question came specifically referring to digital marketeers and advertisers, and the secondary service providers who rely on online spaces. Is there a direct impact to them, and what could be the implications for, because their livelihood depends on those online spaces? Is yeah.
I'm unsure as to who is supposed the question is directed at.
I guess perhaps one of you, Ms. Gehan.
I mean, feel free to add on. I'll just say that there are sections in this or clauses in this bill that also relate to paid content and digital advertising intermediaries that have to also then take steps to ensure, right, that that any paid content from a declared online location is not communicated once an online location has been declared online location. So that kind of liability creation for paid content or digital advertising then also attracts a certain amount of given the vagueness of the offences, a lot of uncertainty as to whether you cannot conduct business, whether it will fall into that category, and if there are these once you also declared a online location, then all other activity also, how do you then engage in, right? So I think there are serious implications, and that is also the concern, whether we've had enough time to understand fully what has been the thinking behind this particular bill.
Yes, thank you. So I think it's high time that we wrap up. It's 10 minutes past our scheduled 1.5 hour time slot. So I'd like to thank all of our speakers for taking their time to be in this webinar, and hope that our audience will be engaging with us in future and direct questions. If so, we can hopefully help you with answering them. And yes, let's wrap up for the day, and we'll hopefully meet you with more discussions like this in future. Thank you.